Hello, everyone. Today I'm here with Paul Nemitz, and we are going to talk about the role of data protection in the age of AI. Welcome, Paul. It's great to have you here.
Thank you, Luiza.
For those who don't know, so Paul is a central figure in data protection in Europe. So he used to work for the European Commission, including as a director for fundamental rights and citizenship between 2011 and 2017, which is that very important period in which the GDPR was being discussed and drafted. We will be talking about that, and especially the meaning of the GDPR, so the European General Data Protection Regulation today in the age of AI, with the rise of the generative AI wave, and in light of the Digital Omnibus as well. In his last 2 years at the European Commission, he was the principal advisor on digital transition, justice, and consumers. He's also a visiting professor of law at the College of Europe. For those who don't know, he's also the co-founder of NOIB. So he works with Max Schrems, protecting fundamental rights. And this year, so later this year, he will publish a book on AI, data protection, and more. But this will, it's still a surprise. So we'll discover later on this year. So welcome, Paul. I'm super happy to have you here. I couldn't think of anyone better to discuss these topics that we will talk about today. So data protection, GDPR, Digital Omnibus, the generative AI wave. Does data protection matter in the age of AI? So does data protection still matter in Europe, even in light of the Draghi report, the pressure that the Trump administration has been also exerting over Europe, and the recent changes that we've been observing? So let's get started. Let's start with some super interesting questions. So, Paul, you were one of the people in charge of drafting and overseeing the enactment of the GDPR. So back in time, the GDPR, for those who don't know, it was enacted in 2016 and it became fully enforceable in May 2018, so just right at the time that Paul was there. So can you tell us more about that experience? So this is a very unique experience, and I think most people have no idea what is it like to be in that position. So anything you want to share from your personal perspective?
Well, first of all, I think it's a very timely debate we are having today. And indeed, it was also for me personally a unique experience. I joined DG Justice as a director for fundamental rights and thus the lead director on getting GDPR on the books in 2011. And I was really not only there, but I led the work as the, let's say, highest official in the commission on this file actively. Of course, under the authority of Vice President Reding at the time. And the enactment already was a battle. I mean, let's be clear about this. Fundamental rights and the law generally, and, German lawyers, they learned this. We learned that, already Savigny in the 19th century said, to get your right is a battle. And the same is true for democracy. Democracy is always a fight. It's never a given. And the same is true for fundamental rights protection. So already at the time when we prepared the proposal, of course, in parallel to initiatives of the European Parliament, there were works having been going on since 2009. There was heavy lobbying from industry, from American government, chambers of commerce, from the United States in particular. And it was clear that this is an uphill battle. And we had as a vice president, Mrs. Reding from Luxembourg, a conservative politician from the EPP. And that was the good thing. That was the lucky constellation because she was steadfast that she wanted to be sure that when she sits down before a computer, she is not being used, she is not being misled, she's not being exploited. And she really stood firm on getting this proposal through. So this was a lucky consolation. Of course, then later, the second element, let's say world historic element, were the revelations of Edward Snowden, which brought it home to everyone how important data protection is. So if you ask me today in the age of AI, I can only say data protection has even become more important. Why? Because on the one hand, the technology of AI makes it even more easy to identify people. We would not have dreamed of the possibilities to target and identify people which AI opened when we started the work on GDPR. The progress of technology thus puts the individual self-determination of people even more in danger, because not only can people be identified, they can also with AI much better be manipulated, much better targeted. So the need to protect people's self-determination, and that's what data protection is about. It's not in the first place about the data, it's about people's freedom not to be manipulated and to decide themselves how they are seen by society. This need to protect this is even higher today than it was at the time. And the second reason why this need is higher is the greed, both of companies who are ruthless in trying to get to the data and use them to manipulate people for profit, but also the ruthlessness of governments. Governments want to know everything about their citizens, including, of course, in dictatorships, to suppress opposition. And the combination of all those, I would say, has just become even more dramatic in a world of Trump and Elon Musk, who don't respect any rules of law, any fundamental rights. And so I think we can be very lucky that in Europe, in contrast to the United States, there is a fundamental right on the highest level of the law, on the level of primary law, namely in our Charter of Fundamental Rights, which has constitutional level value to data protection. So the legislator is not free to do anything it wants, but the legislator is bound by this constitutional arrangement.
Thank you, Paul. And I agree with you about this new technological reality and new threats. And I will go back to that legitimate point and kind of comparing 2016 or that, let's say, that geopolitical context and also techno-social context, right? There was no generative AI, perhaps no AI race, perhaps less pressure from tech companies. Maybe not, maybe I'm wrong. But do you think that, so especially last year, so I've been writing the newsletter, and it's interesting that during my master's and my PhD, I wrote about GDPR and consent and so many European law related topics. And every new opinion, every time there was some sort of publication by Europe, we saw very straightforward this focus on the protection of fundamental rights. So you read, if you read the GDPR articles, you see that the protection of fundamental rights is at its core. And when you read, for example, the AI Act, also the first article, the subject matter article of the AI Act is also so promoting the uptake of trustworthy AI and also protecting fundamental rights in light of the EU Charter of Fundamental Rights. So we know that, at least in theory and as a legal pillar of the European Union, is the protection of fundamental rights. So this we know from a legal perspective. But what we saw happen, and I would say a main trigger for that was the Draghi report, right, from September 2024. Mario Draghi wrote this report on European competitiveness. And then it's a very long report showing that the EU is lagging behind on various indicators, including AI. And then what we saw last year was this narrative shift I've been writing about in the newsletter. So there was the AI summit early in February, where we saw Ursula von der Leyen, and I think the digital boss, I forgot her name. She's in charge of AI. Exactly. Exactly. She said that we are going to apply the AI Act in a business-friendly way. And as a lawyer, I hear that, wow, that's new. How do you apply a law in a business-friendly? The incentives are different, right? The law is kind of shaping behavior, should not be applied business-friendly way. And then we saw J.D. Vance, right, the American vice president. He was looking at the eyes of Ursula von der Leyen, told her, you are going to remove the red tape. And we saw the tariffs, the elements of geopolitical pressure. And we saw Europe definitely change, at least its narrative. So we saw the AI continent plan and apply AI in various initiatives. And I'm always reading, and I know that words matter, and I always read the PR releases, and I don't see fundamental rights anymore. Something has changed. The EU now talks about competitiveness, AI race, innovation, and I don't see, and talks about reforming the GDPR, right? So we see the Digital Omnibus is more or less the concretization of this narrative shift. So for my first question related to that and connecting to what you said about the threats. So the threats have become even worse than they were in 2016, right? Technology is still there, social media and and data harvesting, all that existed in 2016 and 18 is still here and more. Now we have AI manipulation and other AI related threats. But at the same time, the geopolitical context has changed. So do you see the same political willingness in the EU to prioritize fundamental rights? What you experienced firsthand there, do you feel that same vibe, and do you think that the EU is ready or is still interested in prioritizing fundamental rights, or maybe it's not a priority anymore? Maybe now it's maybe hand in hand with innovation or something else.
Well, I don't think that the Draghi report is the starting point for the debate. I mean, the reality is, in a democracy, people get the politics and the policy they voted for. And all over the world, we have seen that people first need to go through a valley of tears to understand that bad policy and bad voting, namely voting for the extreme right, has a consequence for them. And before they they vote for these people, afterwards they regret it. We have seen it in the Brexit vote. Afterwards, now we have a majority who says Brexit was not a good idea. Well, too bad. People in America now are absolutely not fond anymore of President Trump. The opinion polls are very clear. Well, too bad you voted for him. And in Europe too, people have been voting and are still voting for the extreme right. And the reality of Europe is that it has shifted to the right in the second mandate of Mrs. von der Leyen. There is now a potential majority in the European Parliament between the EPP, namely the centrist conservative party to which Mrs. von der Leyen belongs, and also Mrs. Merkel belonged, and Mr. Merz belongs, the German chancellors, and the extreme right. And so this is a reality. Of course, the Commission itself is also composed of more commissioners of conservative and liberal descent, because also in national governments in the member states, things have changed. And so I can only say it's not the Draghi report, the general political positioning of the initiative body, the European Commission, but also in the world, things have changed politically. And we have a new type of politics which caters to a vague feeling of discontent, of businessmen who say, well, this is all no good, we don't want this anymore. There's no real empirics behind it, but it is something which we always had. I mean, I learned in law school, in Hamburg Law School, first semester, whining is the greeting of the businessman. That's nothing new. But what is new is that even though there are no clear empirics of the claims made by these businesses and interested political parties, which are not good for business, which are just right-wing, anti-fundamental rights, anti-people rights, and business will regret it one day that they team up with them, if they do. Now politics caters to these. And we have seen the chainsaw being taken into executives in the United States by Elon Musk. And, in the Commission, there was a little bit an atmosphere of, we also have to do something for business. Well, let's just do something. And so then in a very quick way, something was hot needled, which I would say is not good for business. It's also not good for people. And I am very sure if these proposals go through, we will regret it very soon. And I hope that in the Council and in the European Parliament now a serious debate starts on what all these ideas mean, and we come back to what Europe is good at and what we stand for, namely a practical concordance of competitiveness on the one hand and a strong democracy and strong protection of fundamental rights on the other. You know, we had the same type of atmosphere in the time of environmental protection laws going forward, and it just took some time until also the conservatives realized that it's a good business proposition to be resource efficient, not to use too much resources, not to pollute the environment, and that a lot of money can be made in this way. And I think our politicians in the European Parliament and in the Commission, they just have to remind themselves and be reminded that protecting data of people is a good thing. It's not an obstacle to business. It is the basis for trust in the digital economy. It is basis for long-term money making for digital businesses. And that's what Made in Europe stands for. And in the long run, that's a competitive advantage and not a disadvantage. And I hope we are not going to destroy this competitive disadvantage by just catering to a vague feeling which conservative politicians share with very right-wing parties. And, you know, we'll just wave it through because it's the sign of the times. That's not good policymaking, and it's not in the interest of the people of Europe.
It's interesting that you're mentioning the political background, this more nuanced approach. I wouldn't know that. So talking specifically about the legal aspects, so I teach AI governance, so I know, and I teach the AI Act. And I'll just bring some examples. So the Digital Omnibus, for those in the audience, so there are changes being proposed, so not only to the GDPR, not only to the data protection framework, but also to the AI Act, which has very recently been enacted. It's not even fully enforceable yet, but the Digital Omnibus is also proposing changes to the current text of the AI Act. And I, as someone very familiar with the text, it's difficult for me to understand what's the logic behind. So connecting to what you said. So how come the changes being proposed will in any way improve European competitiveness or improve innovation? And I think I will give an example. So one of the changes is very technical. I'll try to simplify here. So Article 49 of the AI Act has a registration obligation. So if your AI system is high risk, you have to register it. And there is an exception, which I don't agree with the exception. So even if there are two criteria for high-risk AI systems. One of them is Annex 3. So if your AI system is listed in one of the areas of Annex 3, which is education, employment, essential private services, essential public services, those areas, you can still apply for an exception, meaning that you can still say that although your AI system is listed as high risk in the AI Act, it does not pose risk to fundamental rights. So then you document this assessment, and then you don't have to comply with the rules for high risk. And the only hope to increase accountability here was the registration obligation. So Article 49, the original version says, even if you claim that your high-risk AI system or that your originally high-risk AI system does not pose risk, and you're not going to comply with the rules, you still have to register it. And the Omnibus is now proposing to remove this obligation. So the reason given is to reduce the burden, the compliance burden. So now companies that argue that they do not pose risk, they also do not have to register anywhere. Basically, no accountability for companies and entrepreneurs and people who want to abuse the system and simply not comply. The European lawmaker or European authorities, people who drafted the Omnibus are saying, well, it's too much burden, so no registration anymore. So this is a very interesting example. So this was the only hope to make sure that we were still protecting fundamental rights. So we are still trying to make sure that people were not abusing this exception. And now the Omnibus proposes to remove this obligation and kind of, okay, you close the eyes if you don't want to comply and if you want to argue in an abusive way, one of the exceptions, we are not going to even know it because there's no registration. So it's great that you're giving me this additional context, because from a technical legal perspective, there was no way to understand, and various others. So I brought some of the digital, especially for the audience who is not familiar. So among the proposed changes to the GDPR, include. So changes in the definition of personal data, changes to the definition of scientific research, changes to the limitation of the right of access, so limiting it, exception from the right to information, limitation of the right to information, and legitimate interest for AI systems. So this is one of the most, I would say, impactful ones. And it's difficult for me to understand how those changes would make Europe more competitive. So you think, from your perspective, Paul, just to connect back to what you're saying, there is no legal reason and it's pure political pressure, or there is a strong technical grounding behind it, maybe that is not surfacing in this geopolitical debate. So from what I understood that the strongest force here is a political shift in Europe. So I wanted to understand, in your opinion, so two things. First, is it something that is probably going to be overcome? And in your opinion, likely the omnibus is not going to be approved? Or is this shift that we are observing from a legal perspective deep? It goes to the European roots and it actually represents something bigger from that goes to the legal roots of Europe.
Well, so first of all, I would indeed say, there was no serious impact assessment, no public consultation. These proposals are very quickly put together on the basis of a very general instruction from the top, catering to a general mood. And the Draghi report contributed to this general mood, in the usual way of a microeconomist knowing everything, making recommendations on any type of sectoral policy. And in relation to GDPR, it's very, very interesting. In page 319, that's part B, all the footnotes which are in the Draghi report supporting the loud words about a need to simplify and to change. All these footnotes are sources which are not peer reviewed, and consulting, Statista, partially very old sources. So I would say the Draghi report certainly is neither from an economic point of view, nor certainly from a legal point of view, a fortiori, a good basis for this reform. And indeed, and these proposals. And indeed, if one looks at the proposal you just mentioned now, the reduction of the registration obligation, the European Data Protection Board has already said, come on, this is just a transparency rule. This is absolutely no burden. This is one little letter, but it is very valuable because it creates transparency for everyone. So to sell this as an advantage to business, well, I would say, let's have an impact assessment of the costs of registration and the benefits of registration to the enforcement of the law, also to the general public's ability to build trust in these systems. And then let's look at it again. And one could do the same exercise with many other proposals. I mean, I would say generally, companies which produce AI of high-risk nature or general purpose nature are companies which are composed of very intelligent people. And they, even if they are startups, they must be extremely smart, and they are dealing with matters which are extremely complex. So to say these companies cannot handle the, sorry to say, motherhood and apple pie obligations of the AI Act, because the AI contains nothing a reasonable engineer wouldn't anyway do if the aim is to sell in the long term and to be a reliable AI company. To say that they can't handle this and it's too costly and so on is completely unproportionate. And so I would say, for example, on the most important type of AI today, which is general purpose AI, general purpose transformers and large language models, to delay the entry into force of obligations it's just missing the point, because on these we have the most urgent need to have rules. And at the same time, the companies which are able to produce these are the biggest companies in the world. So why do they need yet another time delay to comply? This is all, I think, impossible to explain to a reasonable audience. And we will see that in the council and in the parliament, there will be a lot of questions asked on this. And I hope that at the end, and this is the key point, that the EPP, because they are central on this, the centrist conservatives, the party of Mrs. Merkel, the great party of Mrs. Merkel and of Mr. Merz, they have the obligation not to vote anything through with the extreme right, but to find an agreement with the classic grand majority, namely the Social Democrats, the Greens, and the Liberals. This coalition, I'm sure, in the end will come to a result which brings practical concordance between growth and protection, including also protection of democracy, because that's what data protection is about. It's not only an individual right for people. It's not only for us as not so important. I have nothing to hide. That's not the only reason why we have data protection. We have also data protection because we need to be sure that neither the state nor big corporates know everything about us, because if they do, democracy doesn't work. So we have also a crisis of democracy, and in this crisis we have to take the data protection serious. And it is the EPP's key challenge here not to go with the extreme right wing. And if they're able to do this, I'm rather confident that we will have a good outcome. If they play with the possibility to go with the extreme right, then, well, I can only say people get the politics they have voted for. And like in America, the people who voted for Trump, and like in the UK, the people voted for Brexit, people afterwards will regret it. But I wish it's not going to happen.
Thank you, Paul. As you brought one of my favorite topics, which is AI, the intersection of AI and privacy, especially from this more technical perspective. So when we think, among the changes to the GDPR include the right of access, and it's a good link to what I wanted to ask. So when we think about large language models, and you mentioned general purpose AI models like LLMs, and then we will have general purpose AI systems like ChatGPT, Gemini, and so on. And when we think about those new types of technology that became extremely popular, and we think about traditional data protection law, for example, right of access, right? So right to rectification. So very super important data subjects rights. They became really at the forefront of EU data protection law, starting from the enactment of the GDPR. And it is, so this, I will say, even from a technical perspective, it is challenging. When we think about at least the traditional way we think about right of access. Okay, I should, like the same way Max Schrems did back in 2011, right? So he contacted, there was no, the GDPR didn't exist yet. He relied on some transparency of information, Austrian law at the time, but Max Schrems back in 2011 contacted Facebook and said, hey, I want to have access to all my data. And then Facebook, after some insistence, gave him a file. He printed it, was a big pile. And that's when Max Schrems, he became famous. That was the first episode. So in theory, someone should be able to do the same now, right? So that just explaining to the audience. So according to the right of access, I should be able, if I were covered by the GDPR, I should be able to contact OpenAI and say, hey, I want a file with all information you create from me to train. I want the information you use for training, not the deployment one, not the one I'm inputting into ChatGPT. I want the training information. And because of the way LLMs are trained, it looks like it's very difficult to provide that information, especially due to the way the tokenization how tokenization works and how LLMs are trained. It would not be possible. or rectification, right? Let's see that the same. I see that NOIB, that there have been two complaints by NOIB recently, where there were incorrect outputs. So people incorrect outputs about people, and then we say, okay, you have in Europe, you have the right to rectification. If a company is processing data about me and it's wrong, I should be able to contact them and say rectify. But on a filter level rectification, they should be able to somehow in the original database fix it so that it will never come out wrong again. And because of the way LLMs work and how they are developed, it looks like it's not so simple. We might try to add a filter, output level filter, but there might be different prompts or adversarial techniques that might cause the same problem because it's in the training data set. So it is challenging. And I've been writing my newsletter about that. Europe more or less has two options here. One option would be to say, well, the GDPR was important, but it's times are different now. Maybe we want to adapt and to apply it in a much more flexible way when AI is involved. Maybe a right of access is not so important, or rectification only to the extent it's possible, and so on. This is one position. Another position would be Europe being more, I'd say, by the book and say, as you mentioned, while you have so many intelligent people, smart people building LLMs, so please build an LLM that can comply with all the GDPR data subject rights. Everything that is written there, you have to find a way to comply, and not some exceptional compliance. We want the same. Look at the jurisprudence. So many companies have been fined because they did not establish a storage period, or because they did not allow for rectification. They did not comply. So that it also applies to you, dear AI company. So please find a way to comply. So I've been documenting this. There is a clear, it feels like the EDP, the European Data Protection Board, and the European Data Protection Supervisor, they're more the second alternative. Every time I read their opinions carefully, they don't want to give up. Even the new, they propose the new language for legitimate interest for AI system. It still says you still have to comply with the interests and rights of the data subject. But on the other side, it seems that some sides of maybe the European Commission, maybe some other sides in the bureaucratic engine in Europe, they're not so interested in fundamental rights. They perhaps they want to leave it aside for a moment and let's try to win the AI race. So what's your both your personal view, Paul, and your view to what's happening? So in this scale, who is going to win, and what you think should be the best path here?
Yes, I'm not a great friend of making predictions, but I'm a great friend of participating in the debate, and I think everybody should do. It's not so interesting, the predictions. It's more interesting, how people engage. And I think the time to engage has come again, like at the time of the adoption of GDPR, and we need a lot of people to engage in this debate, because these issues cannot be left just to the tech industry, or for that matter to so-called experts. Why? Because the type of issue which you just mentioned, like for example the very essential right to access, to namely know what powerful companies or governments have about me, this is in the end about the question whether technology rules and maybe the community rules of the company rules, or whether democracy rules. So the question whether the technology has to follow the law or the law has to follow the technology, this is about whether we have democracy or not. Because if we follow the path that we must change the law because there is a technology which is called AI, and in this technology it's not possible anymore to grant people fundamental basic rights of access which they need to exercise their data protection, and which they need to understand what powers others have over them. If we say, well, the technology just can't do it, therefore let's do away with this right, democracy is done. It's finished. So what we are discussing here, when we talk about the very nitty-gritty, specific questions of GDPR changes and also AI Act changes, is, do we have a primacy of democracy and the rule of law over technology and business models? or not? That is the basic question which every time we have to come back to. And now to break this down a little bit further, this question of whether the companies which make huge money with very complex AI systems and spend billions to develop them, whether they can just say, sorry, we can't tell you the copyrighted works we have used here, too bad for you, and we can't tell you whether there's personal data in it, too bad for you. Sorry, I think that is not on. And we cannot tolerate this, because this is the biggest expropriation and the biggest redistribution of wealth, the biggest robbery the world has seen so far, if we would let them go. And I would go one step further. In the United States, there's a lot of litigation going on right now on exactly these rights in the copyright area. For example, the case of the New York Times against OpenAI. And I have read the submissions of the New York Times, and I can only say they're excellent, and I bet they will win. And there are many people in the United States who say this can bankrupt OpenAI. And I would say rightly so. So the argument that our system with ex-ante regulation is more of a business impediment in the midterm may be proved wrong. Because when the litigation takes place in America, when there are triple damages awarded for the use of copyrighted material, and in the debate about access and need to know, and then also need to pay or comply with the law, it's substantially the same debate which we have on privacy and personal data. We will soon see that at least some mechanisms in the United States make not complying with this very costly. And European industry says, we don't want triple damages in Europe, but we also don't want ex-ante regulation. Well, sorry guys, that is just an ask too much. Practical concordance means we need at least one of that, and we need to steer the development of technology in such a way that democracy and fundamental rights have a future. And that means, yes, the technology must be developed so that the rights which are on the books and which are linked to a fundamental right of constitutional nature are respected. And it cannot go the other way around. So I have a very clear answer on this. And let me also say one thing which I have learned from Max and Neub about the empirical reality of access requests. The claim of industry that they are faced with abusive requests in masses and that they create huge costs is completely without any factual basis. The reality is the other way around. Industry is systematically stalling and not fulfilling even the most simple access requests on a mass basis. People have been writing about that a lot. And I'm very surprised, really very surprised, that the Commission makes a proposal now to strengthen the right of industry to somehow get out of access requests. That's really not the issue. So, we have here typically a Buhmann which is created. There are no empirics which support this. And the empirics are actually the other way around. If the Commission would have gone to Neub and have asked, what is your experience with industry following up constructively and fairly, like the law provides, on access requests, they would have got the type of information which people know. I can only say try it. The classic technique of many companies is to come back to people and ask questions back rather than just to answer the access request. So, this is an example where I would say, let's not do it because the companies which are fair to their customers, they will have no problem with access requests. Those who have problems with access requests, well, I would say that's highly, highly suspicious. Highly suspicious. And access requests, by the way, can also be automated. It's not rocket science you need to deal with access requests efficiently.
Thank you, Paul. And continuing what we are discussing now, I want to hear, as I see that you're super involved with AI Act changes as well. So when the GDPR was enacted, we saw the Brussels effect happen, right? So for those in the audience, Brussels effect is this term coined by Professor Anna Bradford. Basically, it reflects Brussels, so the European capital, is to reflect this European influence, regulatory influence over the world. And it became really clear, I would say probably the best case study for the Brussels effect is the GDPR, right? So when Europe enacted the GDPR, various other countries looked at its text, and I can say Brazil is one example, and some of the provisions of the Brazilian data protection law are almost copy and paste from the GDPR. And we saw many other countries in the world getting inspiration, sometimes really copy and paste provisions, and this idea of a fundamental rights-based data protection framework, this way of empowering people through data subject rights and data protection principles, and so on. So we saw that happening with the GDPR. And now with the AI Act, many people, including me, but until early 2025, that's what I thought. I thought we would see the Brussels effect all over again, right? So the AI Act is an AI law, a comprehensive AI law based on the protection of fundamental rights. So promoting the uptake of trustworthy AI while protecting fundamental rights, enshrining the charter, and preventing harm. So I thought that's excellent. That's the EU again. And by the way, it's not by chance. The EU does that like willfully. It's part of European tradition to be this to be this, I would say, this source of light to the world in this regard of showing how to prioritize fundamental rights. So many people thought, including me, that we would see the Brussels effect happening in various other countries copy and pasting the AI Act. And we haven't, absolutely, I would say this hasn't happened. The only law that is more or less has some close inspiration to the AI Act is the Korean AI law. Not so similar, not so such a strong Brussels effect, but a light one. But I don't have many examples to say that yes, the Brussels effect is here. So my question to you is, first one, is Europe still proactively interested in this regulatory influence, or they kind of gave up on that mission? This is one. And do you think that still can happen? That maybe after you brought the example of environmental law, which is a great example. So there were some kind of whining, but then people realized the benefits and kind of things were followed a better path later on. And do you think that could still happen? Maybe 2027, 2028, maybe we'll see a wave of AI regulation, consensus, other countries seeing the European example and trying to say, yes, protecting fundamental rights is important. What are your thoughts?
Well, first of all, I have to disappoint you a little bit, because the AI Act in its original version as proposed by the Commission was not devised in the first place to protect fundamental rights. In fact, the key elements of protection of fundamental rights are now mentioned 105 times in the AI Act. Most of these mentions, and in particular the impact assessment, the fundamental rights impact assessment, but which only applies when AI is used in the public service, with a few small exceptions like certain insurances and credit agencies, have been inserted by the European Parliament, which shows that democratic process ups the fundamental rights protection. Now, on your question on the Brussels effect, I think there also you overestimate and actually not correctly present the interest. Brussels was never aiming for the Brussels effect. Anu Bradford is great in inventing terms, and I think her most important piece of writing is not that book, but the later article with the title "The False Alternative Between Innovation and Regulation." very much more on point now as reading and shorter than the book, but recommended reading to all who go around and think they know it all and Europe just has to deregulate and that's it. That article by the Columbia law professor Anu Bradford is a masterpiece of analysis and should be read by anybody now participating in the debate on the omnibus bill. But the reality is, and I've been more than 30 years in the European Commission, the European Commission has never aimed for the Brussels effect in terms of having an ambition to rule the world with its regulation. Absolutely not. We have always, and GDPR, I was the lead director, we looked towards our duty towards EU citizens. That's who we serve, and that's who we catered for. And the fact that afterwards people have copied it, that was not intended, and we didn't search for that. What, however, we have done is we have said, well, if we want to protect data of EU citizens efficiently, we must make sure that if these personal data are exported to other countries, that the chain of protection continues also in those countries. And the GDPR contains the necessary elements to make sure that this works. And on this, I must say, I am very disappointed by the European Commission's non-action on transfers to the United States. Because in the good times of excellent relations with the United States under the Biden government and even under the Obama government, although the Obama government lobbied hard against EU legislation, President Biden absolutely not. He supported the EU. So in the good past times, we did a very special deal for the United States in the form of self-certification system, which relies heavily on independent bodies within the United States, making sure that the promises of privacy and data protection are complied with, and that also the government, in terms of surveillance, is having checks and balances. And I would say, under President Trump, we cannot rely on any of that anymore. And to say, oh, we first have to wait for court judgments, that's, sorry, we see what Trump is doing every day. And we have seen he has disabled the Privacy and Civil Liberties Oversight Board, which is supposed to oversee the national security agencies. He has disabled the inspector generals. The FISA court doesn't work anymore properly. The FTC is being attacked. All these pillars of adequacy of data transfers to the United States are being systematically dismantled by the bully Trump. And what does the Commission do? Nothing. And, I would say, rather than trying now to lower protection and the Omnibus Bill, this is a point of digital sovereignty. This is a point where we could demonstrate that we have the tools to protect our citizens and we can increase our digital sovereignty by suspending data flows to the United States. The law requires it. And I'm very surprised that, we have a great discourse on becoming independent and furthering digital sovereignty, but at the same time we make proposals which are lowering the protection, but on one of the key elements, namely the continued data flows into the hands of companies which all line up with Trump. And we have seen it in the White House, how they line up with him. We are silent. And, the Commission could be doing something here, very clear, straightforward, nothing. And that is something where I would say, well, again, people get the politics they have voted for. This is due to the composition of the Commission. We now have seen also in the Omnibus Bill that the Justice Commissioner is not in the lead anymore on negotiating GDPR changes, but it is the engineers DG, the technical DG of DG Connect. This is certainly an innovation, but it is an innovation which does away with the types of checks and balances which are completely normal in any government and have also always been normal in the Commission, namely that, of course, there is an element of constructive tension between those responsible for fundamental rights and justice, namely the Justice Ministry in the Commission, the Justice Commissioner, and on the other hand, those who are responsible for industrial policy. And what has the President of the Commission done? She has handed over the fundamental rights protection, GDPR, changes to the Vice President, who is mainly catering to industrial policy. Formally speaking, she is also responsible for fundamental rights protection. But, the proposals don't look like this, and neither she nor the Justice Commissioner have taken a very clear position on data transfers to the United States, which is really something to regret. I think on this, if one looks at the beginning, we talked a little bit about the history of GDPR. At the beginning of GDPR, there were the Snowden revelations. And already then, we talked about digital sovereignty. And we're still discussing about digital sovereignty. We have given ourselves the tools, data flows to the United States, if the situation is not adequate in the United States, and I think it is clearly not anymore, could be suspended. And this could be a tool which could be used to make the position of Europe much stronger. And, in particular, when we are bullied by the US government in the way we have been bullied over the last year.
It's super interesting. I was going to ask you about, so again, we kind of touched the topic at the beginning. I was going to ask again so that before I want to ask you general questions about your AI usage and your final thoughts. But so it's interesting to see that you see the connection between data protection and the protection of fundamental rights as a path to sovereignty as well, right? To democracy and sovereignty. So it's while you were speaking. So I will ask you, but it's super interesting to observe this. This came up various times during our conversation. So if you would say to conclude this more technical / legal part of our conversation, which is the title of our talk, what is the role of data protection in the age of AI? What would you, if you would say, like in a few words, would you summarize that?
Well, I think the role of data protection in the age of AI is to maintain and strengthen individual informational self-determination. People must be able to control, to a large extent, how they are seen by others. And that means that it is not acceptable that powerful organizations, whether powerful companies or the state, have huge profiles about people, which they have today with thousands of parameters, knowing all their dreams, all their wishes, all their sexual, religious, and political orientations, while the individual stands helpless, gets less access rights than in the pre-AI times. The data of individuals should be used as a legitimate interest to train AI. Why do companies of AI, which produce AI, need personal data? The only explanation is to target people and to manipulate them. So the function of data protection is to maintain the freedom and individual determination of people, self-determination. And this is a requirement and the basis for our democratic existence. If the state or powerful interests know everything about us, we don't know what they're doing with the data, we don't know what they know about us, and we don't know what stories they're telling about us because we don't see the answers ChatGPT gives to others about us. Democracy is finished. We cannot have these huge collections of data in the hand of powerful companies or the state. And this should be where the European Commission and data protection authorities should go. We should do away with these all-encompassing profiles. And my hope is that data protection after this so-called reform will still be able to do this. This is a central core, to get rid of these people profiles. Then, if some things on the margin are improved, I like the proposals on the browser settings, the waiting period. There are some good elements. But if they got through, fine. There are other elements like the definition of personal data and like some of the elements you mentioned, which will weaken protection. Certainly, the legitimate interest to use AI for to use personal data for AI training. Absolutely not. I mean, first I would like to understand why they need personal data and for what purposes. So I would say the data protection authorities, to finish with this, will for a long time be the key actors setting the limits of ingerence into personal lives and manipulation of people, also in relation to AI. I don't see that on the basis of the AI Act, the market surveillance authorities or the Commission will really provide protections for people. The ultimate reason is this: at least in the draft of the European Commission, there was no individual right of action for people under the AI Act. So if I see that a company clearly doesn't comply with the AI Act and it concerns me, it touches my interest, it touches my rights, under the AI Act, I can only complain, and my complaint, according to the wording of the Act, is taken into account. But that's very far away from the type of protection of rights we need in the age of AI. In the age of AI, we need, in all these types of laws, including on the AI Act, accumulation of three types of protection. First, an individual right of action. That means if I complain to the authority responsible to enforce the act, I must have a right that they follow up my complaint. And if they don't do it, I must be able to go to court and force them to follow up. Second, we need a well-resourced authority which is able to do the job, which has enough staff and resources, including to win in litigation against these very powerful companies. And third, we must have, in cumulation to these two first options, the right of action in the public interest by qualified non-governmental organizations. If we don't introduce this cumulation of enforcement, the power constellation which we are facing in reality, the top 10 companies, or let's say 5 of the top 10 companies in the United States Stock Exchange, the richest and highest capitalized companies in the world, they are so powerful. And we as individuals, what can we do? Nothing under the AI Act. And that is, let's say, also something where I would wish that if discussions take place in the European Parliament on a possible compromise, well, let's improve on the individual right of action. The Parliament has gone halfway. It has already introduced a fundamental rights impact assessment. I would wish that this fundamental rights impact assessment is not limited only to the use of AI in the public service, but it should be extended to all large language models and to all high-risk AI, and it should be combined with an individual right of action whenever individual rights are concerned. That would be a reform worthwhile. It would bring the AI Act on the level of GDPR, because that's where we have this triple enforcement. Anything below that, based on the proposals of the Commission today, is a minus for protection and goes, in light of the technological developments and also of real power constellations which we face today, in the wrong direction.
Great that you mentioned the fundamental rights impact assessment. I've also written about that, and Philip Hacker, one of the advisors, he also wrote, doesn't make sense, the current language of Article 27, extremely narrow, no point. So great to see that we are aligned on that too. And now I want to ask a general question about AI before we conclude, before your final message. So 2 questions about AI. So first, do you use AI? And if yes, or how do you think would be a nice AI use? And 2, are you optimistic about the future of AI? This, regardless of omnibus or law, but the future, maybe the next 10 years, the next 20 years. And any thoughts on that?
Well, first of all, I have always had the motto, playful approach to the digital. I try out everything, and so I use and compare a lot of AI programs, and I must say it's amazing how the performance has improved over the last years. I think it's very clear that there are breakthroughs in at least the type of performance we see as laymen. Whether this is scientifically a breakthrough, I don't know. But yes, I am fascinated by technology. Am I optimistic? Well, I would say people need to engage for democracy. They need to engage for good laws. And this engagement doesn't end with the voting every 4 years. But, civil society is a good cause, and more people have to engage to make sure that we also in the future live under the primacy of democratic laws, and that we don't become ruled only by technology, only by the rules which technology set, and for that matter, by a combination of Trump plus these companies or Chinese government plus their companies. So all people who want to live freely, self-determined, sovereign in the democratic sense, they now need to engage, and politics needs to understand that this debate about data protection and AI is not something which can be left to the technologists and to the experts. The regulation of the internet, the regulation of personal data, the regulation of AI is societal policy. Why? Because there are data everywhere, and AI is as ubiquitous as electricity. So people need to engage. The highest level of politics needs to take charge, and we have to hold politics accountable for what they are doing now in this very important moment where we are facing a combination of political, financial, technological, and military power in the United States, which is a real threat in many ways to Europe and European democracy. And yes, I am optimistic because I know many people who are ready to engage, but it's crunch time. And I call also on the members of the European Parliament not to abdicate their role, but to take their role on this very, very serious, and not just to leave it to this or that rapporteur. All members of Parliament have a responsibility here, and there's a particular responsibility with the centrist EPP not to succumb to the temptation to wave things through with the extreme right wing. That would be very damaging to democracy in Europe. It would be damaging to fundamental rights protection. And I think it would be damaging to the EPP itself. Because if people see that this is happening, they will not vote for the EPP next time. They will vote for the originals. And so I am actually optimistic that the EPP will understand that there's serious work necessary here together with the liberals, with the Greens, and with the Social Democrats. We need a strong democratic majority on this, not a tight result, a strong democratic majority, like we had it when GDPR was adopted.
Thank you, Paul. And any final message you would like to share with the audience before we conclude?
Well, that was the final message.
That was any final line that you want people to remember if they are busy but they want to think about this conversation?
Don't be a bystander. Engage in this debate. Inform yourself. Look at what the European Data Protection Board says on the proposals. Look at the excellent analysis of the Omnibus by Max Schrems and Neub already in the second version. Write to your members of parliament, join NGOs. This is a moment of democratic engagement. The history of the adoption of GDPR would have been different if we wouldn't have had this enormous engagement of civil society. By the way, also American civil society. At the time, we received a lot of letters, and I remember Jan, who was the rapporteur in the parliament, he also received letter from American civil society also, who said GDPR is also good for the American people. So consumer protection organizations, digital rights organizations, fundamental rights organizations, and also political parties, which want to take their job of shaping our life in the future serious. They now need to get into this, and it's crunch time. Let's engage and make something good out of this.
Thank you, Paul. That was excellent. I'm super happy you have joined me for this conversation. That's it. I hope everyone in the audience enjoyed, and I see you in the next podcast. Bye bye, everyone.
Thank you. Bye bye.